Hey, what's up guys? Today we're going to talk about defenses to negligence. In particular, we're going to talk about the defense called Volenti non fit injuria. Now, where a claimant, a plaintiff suing, either expressly by words or conduct or implicitly, that means by implication, accepts the risk of harm associated by his conduct, his claim of suing the defendant may be defeated by the defense of volenti non fit injuria. For the defense to succeed, the defendant, the person getting sued, has to show that the plaintiff acted freely and voluntarily. Number two, the defendant has to show that the plaintiff had full knowledge and understanding of the risk involved in that particular activity. Number three, the defendant has to show that the plaintiff freely agreed to assume that risk and that the risk to which he consented actually occurred. Volenti non fit injuria is one of the defenses used when people who get sued, who provide sporting activities, get sued for negligence. For example, bungee jumping or skydiving, because such sporting activities are inherently dangerous. So when somebody takes part in such dangerous activities like bungee jumping, skydiving, they implicitly know, it is implied that they know the risk, and it's also implied that they voluntarily agreed to the risk by taking part in such dangerous activities. Let me discuss the case of Imperial Chemicals Industries Limited and Shadwell. Two brothers who were qualified shot firers, employees of the company, sustained injuries at their employer's quarries. Quarries is where you dig the stone, you blow up the stone and collect the stone. The employees had been short of wire. They lacked the wire to test a circuit for firing explosives from a sheltered distance. The brothers disobeyed their employer's instructions and mandatory regulations and tested the electric circuit with insufficient wiring, causing them to sustain injuries from the explosion. Therefore, the English court held that because they disobeyed the employer's strict instructions on the requirement for wiring, they could not succeed in their lawsuit against their employer. The Singapore court in Oberoi Imperial Hotel and Tan Kia Eng approved of the reasoning of the case and held that an employer can rely on the volenti defense where his liability was vicarious. Vicarious liability means an employer is liable for the acts of his employee which were committed during the course of his employment. So the court held that an employer can rely on this volenti defense if he is vicariously liable and the plaintiff employee had combined with the employee at fault to deliberately disobey the statutory rule or any order or mandatory requirements imposed by the employer. The volenti defense can also be used in drunk driving cases where one of the persons injured during the drunk driving sues the driver for negligent driving and causing him injuries. For example, in the English case of Pitts and Hunt, two persons were drinking heavily together, and then the plaintiff, the one who sued, asked the defendant who was driving the motorcycle to send him home. So the plaintiff was the pillion rider. He sat on the back of the motorcycle. So both were drunk. He knew that the defendant was drunk, the person driving, and yet he asked the defendant to drive him home. So clearly, as you can expect, the motorcycle crashed, the plaintiff sustained injuries, and he sued the driver. The court held that in this case, the volenti defense can apply. Why? Because he voluntarily assumed the risk. He knew that both of them were drunk, and with that knowledge, he took on the risk that the motorcycle would crash, and it did indeed crash, and he sustained injuries. In another English case called Morris and Murray, the Volenti defense was successfully invoked when the plaintiff went on a joyride with the defendant on a small plane, knowing full well that the defendant was a pilot on the plane, was drunk, so the plane wasn't driven properly. It had a small crash, and the plaintiff suffered injuries. So his lawsuit against the pilot who was drunk failed because he knew full well that the pilot was drunk. The English court in Woodridge and Sumner also held that the Volenti defense is available in the case of spectators who are injured in a competition or game conducted within the rules of a sport. In that case, the plaintiff was a photographer. He went to this horse riding match, and while he was at the match, he was injured by a galloping horse at the horse show, and he sued the organizer of the horse show, and the organizer of the horse show used the Volenti defense, saying that because he's a spectator, he voluntarily assumed the risk of being injured by galloping horses. So thanks for watching this video on Volenti non-fit injuria.